Y'all, this has got to be the dumbest argument ever. The O'Keefe's family's attorney in the wrongful death suit against her, claiming that because her home is currently under contract, that means she is 1 foot out of Massachusetts. Are you freaking kidding me? Hello, welcome to Alexasrewm, where we are not lawyers, we are not medical professionals, we are not law enforcement, we are just people who have opinions about all things going on in the true crime community, including this Boston Herald article that dropped earlier today, sharing details in the latest reply to her motion to stay the civil suit until the retrial is done and over, saying, quote, they believe she is now 1 foot out of Massachusetts because her home is under contract. I could not believe my eye holes when I was reading this morning, because this has got to be, I've seen some pretty silly arguments from the Commonwealth in a lot of their motions and replies and responses to the defense, but this has got to be one of the dumbest things I've ever heard of. I mean, because my first thought in my head was, well, I mean, if the court didn't feel she was a flight risk for escaping Massachusetts, let alone the country, facing criminal charges, why would she be a flight risk in trying to avoid this civil suit? Why would she then try to flee instead of facing this civil suit when, not for nothing, she's not the one who's paying for her defense in this particular case? The insurance company is going to be. So I mean, but okay, we're here for it. So let's read on. Let's see what they got to say about it. So, defendant Karen Read has 1 foot out of Massachusetts, according to John O'Keefe's family's lawyer, who want to lock in testimony from Read in the wrongful death lawsuit that they filed against her a couple months ago following the declaration of the mistrial. While the attorney for the O'Keefe family wrote in the new court filing that dropped earlier this week, or last week, I should say, that Read has sold her Mansfield home, a real estate agent told the Herald that the home has not officially sold yet, but is under contract. Whenever a sale happens for the home listed at $849,900, Read's criminal defense attorneys listed as lenders on the mortgage, obviously to assist in securing payment for this upcoming retrial, because they've completely bled her dry. Like, I love how everybody on the other side is always like, well, Karen Read's privileged. She comes from money. She has endless amounts of resources to pay for round 2. No, she freaking doesn't. Are you absolutely freaking kidding me? We're talking about hundreds of thousands, probably now upwards of millions of dollars after all is said and done. So, yeah, this is the asset that she's gonna cough up to help pay for some of this. Are set for a big windfall, the Herald has learned. The family of the late Boston police officer has brought the wrongful death suit against Read in 2 Canton bars, which they have both responded to as well. I think, if I am not mistaken, the Waterfall bar has filed a response in support of Karen Read's motion to stay this civil suit until the retrial is completed. And I don't see why that would be any issue. And I mean, not for nothing, usually the civil suit comes after the trial anyways. It doesn't really happen when, hey, we're still trying to figure this stuff out. But hey, I mean, that's just from my own pure observations as a spectator, who drove him to another cop's home at the end of the night. So more background about the trial. We know this. But in a new filing from the O'Keefe family lawyer, the family is pushing for the civil suit to go on as a criminal case plays out. And we had a lot of news break through earlier this week. I will make sure to link my videos. You can go check them out so you're all up to date with all that's going in the criminal case. The O'Keefe family, so this is from the suit which we are going to read, or excuse me, the reply to the motion to stay from the O'Keefe family attorney, also has compelling reasons to lock in testimony from Karen Read because she's practicing her Fifth Amendment right. Who seeks not only to poison the jury pool with her regular communications with the media, which she is allowed to do. She's allowed to talk to whoever the frick she wants. So, like, she's out on bail, innocent until proven guilty. Like, and if you really want to go into that, I mean, now with all this new buzz around what's going on with the Menendez brothers, right? What about Lionel Menendez talking to reporters way back in the day who wrote that book that ended up getting entered into Discovery? Of course she's going to talk to people and get her story out. That's part of building the case, is building strong public opinions as well, public support, right? That's the publicity part of it. That's why you go on shows like Dateline in 2020 and you talk to all these local reporters too, is to get your version of the story out. Reporters and or bloggers, but also has 1 foot out of Massachusetts now that her house is sold, which again is incorrect. It's under contract. It has not been sold. The family lawyer Mark Diller wrote in the new filing, "It is feasible for both criminal and civil cases to proceed concurrently without imposing undue burden upon witnesses or parties," the lawyer added, "to avoid prejudice based on witness unavailability, failed memories, and or Karen Read's attempts to poison the jury pool through her public statements. This court should exercise its discretion to deny a stay." Deny in all caps, right? Like, because we're screaming now. We are screaming through this court filing a stay of the civil case pending the criminal matters resolution. Now, my counter argument to all of this, I mean, who, if anyone, that is actually poisoning the jury pool are, I don't know, people like Michael Morrissey, what with the hostage video? That came out before the trial. Hey, that's just me. I'm just a mere spectator in all of this, right? Read's civil defense attorneys did not immediately respond to comment on Wednesday. So this news actually dropped yesterday, I guess, but this report came out earlier today. And if you have, I mean, I've seen it on Zillow. It's been posted all over the internet too. You can go check it out. But I mean, girlfriend did a good job. She's got a nice home. She's like tucked away. It looks like she's got like nice little property, really nice home. Definitely going to be worth probably loads even more after this second trial for sure. So whoever is the new homeowner, or is going to be the new homeowner in all of this, I mean, man, oh man, will they have stories to tell. Read bought her 4-bed, 3-bath, 2-story colonial on nearly a full acre lot at 481 Gilbert Street in Mansfield in 2017 and listed it for sale over the summer for $849,900, records show. Obviously, that doesn't mean that is what the final closing is. I'd be curious as to see what it closed at. But the law firms for both David Gennady and Alan Jackson, AJJ, Read's attorneys in the criminal case in September each received large mortgages from Karen Read on the home, according to North Bristol County Registry of Deeds records. And I remember when that news broke, everybody was having a hissy fit and who was on the other side, and they're like, oh my God, I can't believe, like, now they own her home. Like, and it's just so dumb. It's like, this is what happens when the county that is prosecuting you, a factually innocent woman, they bleed you dry of everything because they have unlimited resources. As long as there are people living in that county and paying taxes, that county will forever have endless resources to do whatever the heck they please. They can pay Meatball however much he's making, and not to mention all the overtime and all that other for security detail. I mean, I don't know whose pocket that's coming out of, if it's coming out of the state. I'm assuming it's coming out of the county's pocket, but I mean, it's disgusting. And that's how you pay for a legal defense when you're running out of money to pay for your defense. Two legal experts the Herald spoke with confirmed that it's common for lawyers to put up a mortgage for a client to secure legal fees when a home sells. Indeed, each mortgage document states that Reed owes over $200,000 plus interest, a debt to be made in regular payments with the full debt paid off no later than October 1st, 2054. Dang, so that's 30 years from now. Neither Yannetti or Jackson returned Herald calls for comment on this mortgage arrangement. I mean, but guys, it's like, why do they need to? This is something that happens quite often. You put your assets up, whatever assets you have. Hey, I'm literally paying you to make sure I don't go to jail for the rest of my life, right? I don't care at that point. Any material things I own, I mean, it's very easy to rationalize that, right? That's the natural progression if you're going through something as horrific as this. The home on the west side of Gilbert Street was built in 1972 and was most recently appraised at $598,800 according to Mansfield Town Property Record. I am very curious to see what this has to say. I haven't read it yet. This was released yesterday, but it was filed last week. So let's dive in. It's only a couple pages long. So, plaintiff's memorandum of law in opposition to defendant Waterfall Bar and Grill Limited's motion to stay proceedings. Defendant Waterfall Bar and Grill Limited hereinafter. Waterfall requests a stay here largely because allowing discovery to proceed at this juncture and on the eve of the criminal trial will duplicate resources of both the parties and third-party witnesses that would be required to testify in both matters. Plaintiffs oppose defendants' Waterfall's request because the potential for duplication of resources is overstated and does not outweigh the prejudice that will burden the plaintiffs should this court order a stay of the civil proceedings. First, the potential for duplication of resources fails to recognize that discovery in the civil case extends beyond the relevant inquiries of witnesses in the criminal case. So, I mean, by duplication of resources, do you mean money? Do you mean experts? Do you mean... I'm just a little confused by what exactly you mean by that, but okay. Second, Waterfall's assertion that a brief stay poses little risk of prejudice to the plaintiffs is inaccurate. Not only is defendant Reed using the media to poison the jury pool, but also any delay risks the degradation of evidence, including witnesses. Oh, we got a footnote. Where's the footnote? Where's the footnote? I can't find it. Oh, nope. That's an apostrophe. I am blind. Including witnesses' memories. And yes, I can understand that being true. Obviously, the longer you wait, your memory starts to shift. Maybe you confuse certain things with other things. I get it, but they still have plenty of transcripts to refresh their memory. So I don't really understand why. And not for nothing, why are they proceeding or attempting to proceed with a civil suit before she's even been convicted of anything? We saw this in the Rebecca Zahow case, the woman who was found, I think, hanging from a balcony, and they claimed it was suicide, and then the investigation led them to believe that it could have been, I think, the brother-in-law or the cousin or something like that, and they didn't have enough, I guess, to press criminal charges, so the family ended up taking them to civil court, and I believe they won in that case, but I mean, this is usually the progression of how this stuff works. Not that I'm an attorney or have any legal sense, but I mean, just as a mere spectator of the sport, that's generally how things roll. So, I mean, for me, the civil suit has always felt like, well, this is our plan B, right? If we can't get the conviction, we're going to definitely go for this, and we're going to just bleed her dry for every single last dollar she has. But I think, too, they would still, if she did get a conviction, which she never will, but if they did end up convicting her, they would obviously also go for the civil suit, because we know Paul O'Keefe needs more renos on his house, right? Because that's what's really important, guys, is Paul O'Keefe getting his, finally building his dream house. Therefore, the purported concerns over duplication are outweighed by the hardship and substantial risk of prejudice plaintiffs would face should a stay be granted. I mean, the only one who's facing hardship and substantial risk in terms of at least financially, economically, is Karen Reed. Like, you're seeking to bleed her dry. Legal standard, the movement carries the heavy burden of establishing that a stay is warranted. See Microfinancial Inc. versus Premier Holidays International Inc., citing Austin versus Unarco Indus Inc., 705, yada yada. A motion to stay proceedings is ordinarily a matter addressed to the sound discretion of the trial judge. Travenol Laboratories Inc. versus Zotal Limited. Courts must weigh the interest of the plaintiffs in proceeding expeditiously against the burden on defendants. Del Val versus Bechtel Corp. Quoting Nowazik versus Matig. I'm not even going to say that. This is a whole lot of hefty words that I'm going to get way too tongue-tied over. A general stay is just more case law. A general stay of all civil discovery is not by any means the best option available to the court or to the litigants. Stays can and should be tailored to avoid undue prejudice. But again, like, what's the prejudice? A court can allow civil proceedings to progress as much as possible without prejudicing the relative interests of the litigants. Green versus Crosby. Citing parallel civil criminal proceedings. See also United States Securities and Exchange Commission versus Canodia. Denying stay during criminal proceedings with exception of two specified depositions. When a stay of proceedings is requested, the rights to the parties to the civil action are to be considered as equal. See U.S. Trust Company of New York versus Harriet. The overall interest of the courts that justice be done may very well require that the compensation and remedy due to a civil plaintiff should not be delayed. Require that the compensation and remedy due a civil plaintiff should not be delayed. I mean, it almost feels like they don't want her to be so broke that they can't pay her if they ended up winning the civil suit, which they won't, because she's not going to get convicted. Like, she's just not. So, I mean, I don't know. I really don't know what the angle is at this point. But all right, here's the argument. Defendant Waterfall overstates its concern that allowing civil discovery to proceed will force witnesses. My goodness. Defendant Waterfall overstates its concern that allowing civil discovery to proceed, because again, remember, a lot more stuff can come into discovery in civil court versus a criminal proceeding, and I hope there is a lot that does come out, because I think there's going to be even more. Then, as we know, Beverly, who's going to be sitting on the Reed trial for round 2 at the end of January. I mean, at least that's the way it seems right now. That was the statement that was put out. We know that there's only so much that is going to actually come into play, but you bet your bottom dollar that they're going to bring in those ARCA guys once again for the civil suit. And the ARCA guys, it's not going to be hidden to the fact that those experts were hired by the FBI, who were conducting an investigation into the investigation, along with however many other experts they're going to bring into testify on her behalf, as well as the waterfall. So it's all 3 of them. I mean, it's gonna be cray-cray. So will force witnesses to testify in overlapping proceedings, because witnesses can participate in both the civil and criminal matters without undue burden. So I'm very curious what their plan is. Like, they want to go to trial now? Or they want it to happen at the same exact time as the retrial? I'm just very confused. Like, what is their approximated timeline, ideally? Only a few of the witnesses relevant to Waterfall's liability here overlap. For example, many of the ownership and/or staff of Waterfall are not expected to testify in Reed's criminal case, even though they are expected to testify in the civil case. Moreover, facts relevant to the criminal matter for Waterfall employees' agents do not align with the civil matter, and the inquiry is expected to be wholly different in the civil case. But here's my issue too, right? They're saying that a lot of the staff and owners from the Waterfall, for example, this is just speaking on behalf of their response, right, in support of the motion to stay. How do they know that the retrial isn't happening until the end of January? I'm fairly certain that the defense is still pooling even more evidence. They probably haven't finalized their witness list. Like, they don't have to do that, I don't believe, until the weeks leading up to the actual trial. So how can you even say who they're going to call and who they're not going to call? You don't know that. They might end up calling more people from the Waterfall or different people. I don't know. That's just, so I don't think it's fair for them to say, for example, they're not expected to testify again. Again, how do you know? You have nothing to do with a criminal case. So that's just pure speculation. But I mean, I don't know. What do you think? Like, that just seems like a very misrepresented statement. Moreover, facts relevant to the criminal matter for Waterfall employees, agents do not align with the civil matter, and the inquiry is expected to be wholly different in the civil case. So I guess meaning any of the witnesses that testified that were at the Waterfall. But I mean, in terms of employees, yeah, I mean, they would be relevant to the civil case, because the whole point of them going to the civil case is so that they can prove she was drinking and driving and ran Officer John O'Keefe over with a car. That is the point of this, right? Because they're not confident, clearly, that Morrissey can come through and get them a conviction. I mean, that's just my opinion, but this is very much how it feels like. So I don't think that's very fair to say. Again, like, you don't know, and you don't know how the defense is going to use some of these witnesses from even the previous case. It's not going to be a copy and pasted retrial. What would be the point of that, right? They're going to try out new things. They're going to test new things, bring in different people potentially. So I just feel like this is very like, okay, but how do you know? You yourself have nothing to do with a criminal case. And the inquiry is expected to be wholly different in the civil case. The operative time relevant to Waterfall's liability, time of service, does not align with the relevant times in the Reed criminal matter, time of Reed's drunk driving. But again, not for nothing, Lally was never able, or I won't even just say Lally, the Commonwealth was never even able to pinpoint a timeline of events. I mean, yeah, we could see her on the surveillance video footage of her accepting drinks, right? We saw her at the bar at CF McCarthy's. We saw her at the Waterfall. We saw her at those 2 different bars. We, heard about the receipts. We heard the testimony from some of the bartenders. So, I mean, but still, in terms of her BAC level, when her actual last drink was, I mean, none of that was necessarily proven, and there really isn't a clear, exact moment to moment, minute to minute timestamp of when her last alcoholic beverage was consumed into her system. Like, there just isn't. I mean, yeah, in times of service, so from when they were open to when they were closed, sure, but I mean, again, I just feel like there's a lot of crossover, and that can't be denied. Like, anecdotal testimony of Reed's visible intoxication at Waterfall from other inebriated patrons of the Waterfall may not carry the same weight as bar staff who were supposed to be trained professionally to identify visible signs of intoxication. Bro, it doesn't take a rocket scientist or an ARCA expert or a BAC expert, whatever, right, to look at someone and tell if they have some sort of buzz. You just look in their eye and you can see, oh, you got like a little bit of water in your eye. I mean, it's like, unless you've never consumed alcohol ever, and the only people you associate with are people who don't drink, which is possible, but most people know what the signs of intoxication are. You can tell when somebody is feeling themselves, right? When they've had a couple of drinks, they might not be drunk, but they, certainly have a buzz on. It's not that hard to tell. So professionally trained to see or identify visible signs of intoxication, like, it doesn't take a freaking PhD to clearly say, oh, hey, that person's slurring their speech, or that person, is kind of swaying side to side, or is stumbling a little bit, or is, accidentally spilling their drink all over the place, right? Like, it does not take a rocket scientist to put 2 and 2 together, but okay. Clearly you need a PhD, according to this guy. The O'Keefe family also has compelling reasons to lock in testimony from Karen Reed, who seeks not only to poison, she's poisoning us, guys, the jury pool with her regular communications with the media, because apparently if you're a criminal defendant, you're not supposed to communicate with anybody other than your attorneys. You're supposed to sit locked up in your apartment all alone, not fighting for your life, not trying to get your story out, not trying to get the truth out. But I mean, okay, yeah, you forfeit all of your rights as an American citizen before you're even convicted, before you're even found guilty in a court of law, which she was never. So, I mean, and even when you are convicted, you're still allowed to speak to the press. You're still allowed to make certain arrangements. I mean, how many inmates hop on Piers Morgan and tell their stories, right? It's just like, what? And or bloggers, and you know who that's being directed towards, but also has 1 foot, and again, this is my favorite, 1 foot out of Massachusetts now that her house is sold, which it has not. It's under contract. Moreover, the risk of witness memories fading and our relevant witnesses from Waterfall moving on with their lives and becoming uncooperative is not insignificant. Here, as in Del Valle, a delay of discovery poses a real risk of irremediable loss of witness memory and a risk of witness unavailability. The resulting prejudice to plaintiffs' ability to prove their claims would be substantial, outweighing the defendant's reluctance to respond to the plaintiff's discovery request. So essentially what they're saying is, well, the longer we put this out, I mean, we might not be able to call certain people, and we won't be able to put forth a fair trial. And I get the whole, lapse in memory. It happens, more and more time is spaced out. But not for nothing, this trial, the criminal trial, has dragged out for over 2 years, almost 3 years, this case has been dragged out. So, I mean, not for nothing, if you were really concerned about witnesses not being available, lapse in memories, well, why didn't they file the civil suit earlier, right? If you're so worried about that, and you're so gung-ho in your convictions of this, why did you wait until the trial played out, right? And again, to my earlier point, that's usually the natural stages of progression in these matters, at least from what I've observed, right? In other cases, the civil suit typically comes after the criminal trial, but again, if this was such a grave concern, then why wasn't this suit filed a year ago? A year and a half ago? I don't know. What say you? So, you could say everybody's at fault at that point. The O'Keefe family has a right to a timely resolution, as does Karen Reed. You think Karen Reed wants to go through this? You think the Waterfall Bar and Grill? You think C.F. McCarthy's? No, nobody wants to do any of this. Nobody wants to do any of this, but it's you. It's all you. Based on Waterfall's request, a stay here could be indefinite. Additional delays in the criminal trial's resolution, including another mistrial. So are you anticipating another mistrial? I mean, I don't know. A lengthy appeal or other legal complications are real possibilities here. If the defendants received the requested stay, plaintiffs likely would be prejudiced by fading witness memories and delays in justice. And the only delay in justice here is the delay in justice for Karen Reed and Officer John O'Keefe. By you doing this, you are further delaying justice for Officer John O'Keefe. Every time you fight the facts of this case, of the criminal case, proving that she did not unalive Officer John O'Keefe. She did not strike him with her vehicle. She did not. That was the only thing that was proven in the first trial. Every day you fight that fact is another day wasted that could have been spent actually seeking truth and justice for Officer John O'Keefe. Conclusion: this court should deny defendant Waterfall's request to stay these civil proceedings because overlap between the civil and criminal cases is minimal. The whole reason for the civil case is because of the criminal. Okay. And many of the issues relevant to the Waterfall's liability are not significant in the criminal matter. It is feasible for both to proceed concurrently without imposing undue burden upon witnesses or party. And that's so funny too, is like they're saying many of the issues that are relevant to the Waterfall's liability aren't significant in the criminal matter. And why? Why are they not relevant? Because they don't exist. Because there aren't issues. Because they didn't overserve her. They didn't. Like, it's just... What? And if you're saying that, then you're kind of admitting the fact as to why the frick we're here. Like, what? Without that, how do you have a civil case? It makes no sense to me. To avoid prejudice based on witness unavailability, failed memories, and or Karen Reed's attempts to poison the jury pool once again through her public statements, because again, if you're a defendant who's fighting for your life and you haven't been convicted by a jury of your peers, you lose all your basic human rights. You lose all your rights as an American citizen. You don't get to practice First Amendment speech. You don't get to practice your Fifth Amendment rights. You don't get to practice any of that. You are just a cog in the machine, right? You are just a lifeless human. I mean, how disgusting. This court should exercise its discretion to deny a stay of the civil case pending the criminal matters resolution. What a clown this guy is. And this was on my birthday. What a freaking clown. So if you want to read that, I will link it in my description box below. But I mean, like, what? I saw that on my feed this morning. I'm like, this is literally the dumbest thing I've ever read in my life. Because again, I kept thinking, in a criminal court, they literally released her on bond. And because they didn't see her as a flight risk, why would she then be a flight risk in regards to the civil suit? Like, it makes no sense. It makes no sense whatsoever, but again, that's my opinion. What say you? Do you think that the court will rule in the favor of the plaintiffs, aka the O'Keefes, or are they going to rule in favor of the defendants? Karen Reed, Waterfall, CF McCarthy's. What say you? I want to hear your thoughts in the comment section below. And with that being said, if you enjoyed today's video, make sure you hit that subscribe button. Make sure you hit the notification bell so you do not miss the next Karen Reed update from me. And make sure you hit that like button because that tells the YouTube gods and algorithm that this is newsworthy news. And it is. It is, because the more eyeballs we get on this case, the more pressure we put on the DA's office, the more pressure we put on other government officials, other state legislators, other local government officials to step in and help and do something and make the kind of progress and change in their communities that their community is actually longing for. That is what they're fighting for. This case has evolved into so many different things, and I think it's going to be, honestly, something that is talked about for many, many years to come, something that's probably going to even be taught in schools. I mean, a lot of it has already, the elements in this case, Turtle Boy's case. So it's a fight for justice, and it's a fight for also the right to protect our rights as American citizens, which, I mean, nowadays it feels like we're the last people that are thought of, right? The last people in our own country that are thought about. So with that being said, thank you so much for watching, and I will see you in the next one.